In the Circuit Court of Cole County, State of Missouri. Missouri Republican State Committee. Plaintiff. V. Case number 24 ACCCO2151, Secretary of State. And Darrell McClanahan, 3. Defendants. Findings of fact, conclusions of law, and final judgment. In this case, the Missouri Republican State Committee (MRSC) seeks an injunction preventing the Secretary of State from placing Darrell McClanahan on the Republican ballot for governor at the August 6, 2024 primary election. On May 9, 2024, the court conducted a trial. Plaintiff, MRSC, was represented by attorneys Lowell Pearson and Derek Good. MRSC presented evidence in the form of testimony from its executive director Miles Ross and exhibits. Defendant, Mr. McClanahan, appeared by attorney David Rowland. Mr. McClanahan did not present testimony, but 3 exhibits were admitted. Defendant Secretary of State was represented by attorney Frank Young. The Secretary did not present any evidence, though his responsive pleading is informative. In his responsive pleading, Defendant Secretary of State asserts that he does not have the statutory authority to remove a candidate from the ballot once they have filed with his office. As the court stated in Vowell v. Candor, 451 SW3D 267 Mo. App. W. D 2014, Section 115.387, RS Mo. Does not reflect that the legislature intended the Secretary of State to judge a candidate's qualification. ID. At 275. Rather, Section 115.387, RS Mo. is a ministerial task performed by the Secretary of State. ID. At 274. CP.4, Defendant Secretary of State's answer to plaintiff's petition for injunctive relief. The court has not been presented with requisite facts nor legal authority to support the relief requested. Consequently, the court rules in favor of the defendants. Parties. A. MRSC is the state committee for the Republican Party created under Section 115.603. RS Mo. B. The Secretary of State is Missouri's chief election official and is responsible for transmitting to election authorities a certified list containing the name and address of each person who has filed a declaration of candidacy in the Secretary's office and is entitled to be voted for at the primary election, together with a designation of the office for which the person is a candidate and the party the person represents. Section 115.387, RS Mo. C. Mr. McClanahan filed a declaration of candidacy with the Secretary of State on February 27, 2024 to seek the Republican Party's nomination for governor. Venue and jurisdiction. D. MRSC brings this lawsuit under Sections 526.010, RS Mo in Missouri Civil Rules 92.01 to 92.04, seeking relief from the court to enforce its associational rights protected by the First and 14th Amendments to the United States Constitution. E. Venue is proper in this court under Section 508.010.2 because the Secretary of State's office is located in Cole County, Missouri. Findings of fact. 1. Under Missouri law, an individual who wishes to compete in a partisan primary election for any federal or state elected office must satisfy 2 requirements. 1. Pay a filing fee to the treasurer of the state party whose nomination the candidate seeks. Then 2. File a declaration of candidacy with the Secretary of State's office between the last Tuesday in February and the last Tuesday in March. 2. Due to the large number of candidates who wish to comply with these requirements on the first day of filing, the larger political parties, including the Republican Party, set up tables near the Secretary of State's office on that day and provide representatives to collect filing fees from candidates. 3. Once a party has given a candidate a receipt for their filing fee, the candidate can then approach the Secretary of State's representatives and submit that receipt alongside their declaration of candidacy. 4. This system provides a reasonably quick and efficient way for candidates to comply with the legal requirements for taking part in the primary elections. 5. The opening day of each filing period sees hundreds of candidates arrive at the Secretary of State's offices. 10. It is common for the Republican Party to accept filing fees when a candidate offers them without first reviewing the candidate's background. No state law requires a political party to accept a filing fee simply because a candidate HGS offered it. No state law requires a political party to accept a filing fee at the time a candidate offers it. No state law requires a political party to accept candidates' filing fees on a first-come, first served basis. Where a candidate is not already known to the party's representatives, the party could decline to accept that individual's filing fee altogether, or it could delay accepting the filing fee until such time as the party has reviewed the candidate's background. Members of the Republican Party have recently discussed the possibility of CJ would-be candidates for primary elections, with the goal of CTING the filing fees of those that party leaders felt did not sufficiently align with the party's values. Several months before the start of the 2024 primary election filing period, a Republican-affiliated organization circulated a 55-page document explaining the goals, process, and legal basis for vetting candidates in advance of elections. Some county-level Republican Central Committees implemented this sort of vetting system for the 2024 election cycle. The Vernon County Republican Committee refused to accept the filing fees from 8 would-be candidates in the August 2024 Republican primary election. See Vernon County Republican Committee v. Vernon County Clerk, Case Number 24 VACV 00185, *1 Vernon County CIR. Court. May 7, 2024. 14. On the first day of the filing period for the 2024 primary election, the plaintiff accepted McClanahan's filing fee, which he offered because he wished to run for the Republican Party's nomination for governor. 15. The plaintiff gave McClanahan a receipt for his filing fee, which he submitted to the Secretary of State's office alongside his declaration of candidacy. 16. This was not the first time the Republican Party had chosen to accept a filing fee from McClanahan. 17. In 2022, McClanahan was on the Republican Party's primary election ballot as a candidate for U.S. Senate. 18. After the Republican PAFT accepted McClanahan's filing fee in February 2024, the party's executive director became concerned that McClanahan may have made statements that could be construed as racist or anti-Semitic. 19. The plaintiff determined in some manner that it did not want McClanahan to be on the Republican ballot in the August 2024 primary election. 20. On March 4, 2024, an attorney for the plaintiff sent McClanahan a letter stating that it had decided not to accept his filing fee and that it was asking the Secretary of State to remove his name from the ballot. 21. That same day, the plaintiff sent a letter to the Secretary of State asking for McClanahan to be removed from the ballot. 22. On March 7, 2024, the Secretary of State's office responded with a letter in which it stated the office did not have the authority to remove a candidate from the ballot. 1. The court takes no position on this issue because the only salient fact, which is undisputed, is that the plaintiff does not wish to be associated with McClanahan. The plaintiff's reasons for its position have no legal or constitutional relevance. 23. The plaintiff filed its petition for injunctive relief on March 21, 2024. The petition does not seek declaratory judgment. The petition does not allege that any person has violated state or federal law. The petition does not identify any provision of Missouri law that it alleges to be unconstitutional, either facially or as applied. It is undisputed that McClanahan has complied with the statutory requirements to be included as a candidate for governor on the Republican primary election ballot. The petition does not contend that Missouri law gives the Secretary of State any _CE_C and when it comes to whose names will be placed on a primary election ballot. The petition does not identify any statutory mechanism that would authorize the court to order the Secretary of State to remove a candidate from the ballot. The only specific relief the petition requests is for the court to enter a permanent injunction enjoining the Secretary of State from certifying Mr. McClanahan's name on the Republican Party primary ballot for governor. The petition does not allege that the plaintiff has suffered any existing harm, but rather that it will be harmed if the Secretary of State certifies McClanahan's name for the primary ballot. The plaintiff did not offer any evidence regarding the nature or extent of any harm it might suffer if the court does not grant the relief it has requested. 2. Indeed, the plaintiff has not served a copy of its petition on the Attorney General, as would be required by Section 527.110, or the Speaker of the House of Representatives and President pro tempore of the Senate, as would be required by Section .1.185. Conclusions of law. The plaintiff has not properly pled and proven any constitutional violation. The plaintiff asserts that certifying McClanahan for the primary election ballot, pursuant to Section 1-15.387, RSMO, would force an unwanted association with Mr. McClanahan, violating the plaintiff's First and 14th Amendment rights. Section 115.387 gives the Secretary of State a Ministerial duty to certify the names and addresses for the primary ballot. Fowle v. Candor, 451 SW3D 267 Mo. App. W. D. 2014. If a litigant contends that a ministerial duty imposed by a statute, as opposed to a discretionary choice made by a public official, would result in a violation of its constitutional rights, it should challenge the validity of the statute. Registered greater than, but the plaintiff here does not challenge the constitutionality of the statute that would require this alleged harm, greater than either facially or as applied. The plaintiff's failure to challenge the validity of any statute or discretionary decision leaves this court with no authority to rule on the constitutional question the plaintiff attempts to raise. Asterisk. 3. Defendant pointed out a proper challenge to an election statute would require the court to follow a prescribed course of analysis. First, the court would have to presume the constitutionality of the challenged law, and the challenging party would have to prove that the statute, clearly and undoubtedly, violates the Constitution. Black River Motel, LLC v. Patriots Bank, 669 Sal.3D 116, 123 Mo. Bank 2023. Then, where the statute at issue was an election-related law, the court would be required to apply the framework established in Anderson v. Celebrez, 460 U.S. 780, 1983, and its progeny. The Anderson analysis requires a court deciding whether a state law violates First and 14th Amendment associational rights to weigh the character and magnitude of the burden the challenged rule imposes against the government's interests in maintaining the rule. Timmons v. Twin Cities Area New Party, 520 U.S. 351, 1997. The plaintiff may not evade the prescribed analytical framework by failing to properly plead its cause of action. 4. The cases the plaintiff cited involved plaintiffs challenging either the constitutionality of a statute or the discretionary acts of government officials. In Califf. Democratic Party v. Jones, 530 U.S. 567, 577, 2000, the plaintiff challenged the validity of a state statute that gave voters who had refused to affiliate with a party the authority to participate in the selection of that party's nominees. In Duke v. Cleland, 954 F2D 1526, 11 TTCIR. 1992, the plaintiff had been excluded from the ballot because a state law gave party members on a state commission the discretion to vet the inclusion of certain candidates on the party's primary ballot, and the party's members exercised that discretion in regard to the plaintiff candidate. Instead, the plaintiff has only asked for equitable relief. But, a court of equity will not assist a plaintiff who comes to court with unclean hands. City of Kansas City v. New York Kansas Building. Associes, LP, 96 SW3D 846, 862 Mo. App. W. D 2002. A litigant with unclean hands generally is not entitled to equitable relief such as an injunction. Purcell v. Cape Girardeau, County. Common, 322 SW3D 522, 524 Mo. Bank 2010. Where a plaintiff's own con_duct is the source, or part of the source, of their equitable claim, that claim is barred. Kim v. Mercy Clinic Springfield Communities, 556 SW3D 613, 618 Mo. App. S. D 2018. Here, the situation of which the plaintiff complains only exists because it made the voluntary decision to accept filing fees, on 2 occasions, that McClanahan offered in accordance with Missouri law. The importance of the plaintiff's decision to accept McClanahan's filing fees is illustrated by the Missouri Supreme Court's decision in Curtis v. Mo. Democratic Party, 548 SW3D 909 Mo. Bank 2018 and the General Assembly's subsequent decision to amend Section 115.357. In Curtis, an incumbent member of the Missouri House of Representatives offered the Missouri Democratic Party a filing fee in an effort to declare his candidacy for the Missouri Senate, but the party's representatives refused to accept the fee and, although the candidate left the money on the party's table, the representatives would not sign a receipt for the fee. ID. At 912-13. Because the candidate could not present a signed receipt for the filing fee, the Secretary of State's office would not process his declaration of candidacy. D. At 913, the representative sued, arguing that either the Democratic Party or the Secretary of State's office had a ministerial duty to accept his filing fee. ID. At 915, the Missouri Supreme Court held that the Democratic Party had no duty to accept the candidate's filing fee in part, because the Secretary of State may receive the filing fee to be forwarded to the treasurer of the party. ID. At 917, the Curtis Court left open the possibility that Section 115.357.2 gave the Secretary of State a ministerial duty to accept a candidate's filing fee. ID. At that time, state law allowed a candidate to submit their filing fee to the official accepting the declaration of candidacy. Section 115.357.2, 2018. But in 2020 the General Assembly removed a option. Candidates required to file their declaration of candidacy with the Secretary of State now must pay the required sum directly to the treasurer of the appropriate party _T. Section 115.357.2. Missouri law has long held that in appropriate cases a party may waive their rights and, once so waived, it may not later seek to revive them. In order for such a waiver to be effective, 3 elements must be shown. 1. The presence of an existing right, benefit or advantage. 2. Knowledge of its existence. And 3. An intention on the part of the party to relinquish it. Cooley v. Marshall, 305 SW2D 879, 882 Mo. App. K. C. 1957. All 3 elements are at is feed here. The plaintiff is a sophisticated entity and the record shows that it was not only aware of a party's authority to reject a filing fee offered by a candidate, but that segments of the Missouri Republican Party have already adopted a policy of rejecting filing fees from any candidate who has not completed a prescribed vetting process. The plaintiff could have chosen to avoid potentially unwanted associations by rejecting filing fees for statewide candidates. It did not do so. Instead, when presented with the binary choice of accepting or refusing filing fees from McClanahan, the plaintiff twice willingly created the very association of which it now complains, accepting the filing fees and giving McClanahan the receipts he filed along with his declarations of candidacy. In this case, there is not a sufficient basis for the court's intervention. 5. The plaintiff's argument implies that, despite its choice to accept a candidate's filing fee, a party's leadership can assert its right to have a candidate removed from a primary election at any time as long as party leadership can plausibly claim to have previously been unaware of whatever controversial circumstances triggered their desire to disassociate from the candidate. This suggestion finds no support either in statute or case law. If, having accepted a candidate's filing fee, a party's leadership becomes concerned that the candidate does not reflect the party's values, its remedy is to make the voters aware of the basis for the leadership's concern, then to let the voters determine for themselves whether they share that concern. Even though a claim for injunctive relief is founded on violations of constitutional rights, there remains the necessity of showing irreparable injury. Farm Bureau Town and Country Inns Company of Missouri v. Angoff, 909 SW2D 348, 354 Mo. Bank 1995. The plaintiff did _note present to the court any evidence that having McClanahan on a primary election ballot WOU_LD cause it any injury. McClanahan's presence on the primary election ballot is not necessarily an endorsement v of the candidate by the party. It merely indicates to the public what the evidence in this matter shows, that the plaintiff accepted his filing fee and that he then filed a declaration of candidacy with the Secretary of State's office. Additionally, one of the central motivations for states adopting primary elections as a method of choosing nominees was to ensure that the nominees would reflect the will of political parties' voters rather than the insiders who control the party's committees. THH Republican Party. Cox, 892 F3D 1066, 1081-82, 10, CIR. 2018. It is the voters in _A.PR_AMAFR. Y election, not the party leadership, who are the best barometer of the party's values. See id. At 1082-83 the associational rights of a political party expand beyond the party leadership, and would be toothless if party bosses could dictate how candidates can qualify for the primary ballot, perhaps, for example, by requiring candidates to win the support of party bosses in order to qualify for the primary ballot, leading to primary elections with a single candidate on cent ballot. The plaintiff did not offer any evidence as to how it might be harmed by the fact that the Republican Party's own voters would have the option of casting their primary ballots for McClanahan. The plaintiff has made clear that it does not endorse his candidacy and it remains free to publicly disavow McClanahan and any opinions the plaintiff believes to be antithetical to its values. If the party's voters eventually did choose McClanahan as their nominee, it could merely indicate that the plaintiff did not actually know or correctly represent the values or interests of its 10. Own rank and file members. On the other hand, if, as in the 2022 primary election, a broad majority of the Republican Party's voters choose to vote for other candidates, this would seem to vindicate the plaintiff's claims about the party's preferences far more effectively than any statements the plaintiff might make. In either circumstance, the plaintiff has not clearly stated any particular harm it believes it would suffer from McClanahan's mere presence on the ballot. This failure to articulate or prove any specific harm that might result in the absence of the requested relief ALSD precludes this court from granting the relief sought. For the reasons set forth above, including, even on constitutional grounds, the absence of requisite facts or legal authority to support the relief requested, the court enters judgment in favor of the defendants. It is so ordered. May 17, 202, 74 at 7L, date Hun. S. Cotton Walker. Circuit Court Judge, Division 2 19 inches Judicial Circuit, State of Missouri. 11. In the Circuit Court of Cole County State